welcome to the First District Court of Appeals. We have two cases on our docket scheduled to be argued this morning. The second case will be argued by Zoom. The first case is case number C-240254, Skiles versus Hamilton County, Ohio Auditor. Are the parties and their counsel present and ready to proceed? All right, you may come forward. You may. Would you like to reserve time for rebuttal?
Yes, Your Honor. With the court's leave, I'd reserve 3 minutes.
All right. You may begin when you're ready.
Well, good morning, and may it please the court. My name is Scott Skiles. I'm an attorney representing myself and my favorite co-appellant, my wife, Samantha, in our appeal this morning. We're here today because the auditor's valuation of our property, our house, is wrong, and it's been wrong for several years now. It's $535,000. That relies entirely on our purchase price. So the tax lien day for all the proceedings today is January 1st, 2022. So the question before the BOR and before the trial court and before
You purchased
this
it
court,
soon afterwards, right?
That's right,
Soon after that
mid-January. I think January 12th or 13th is the date of our deed. So no dispute that if it was an arm's length sale, highly probative of the value of the property because it's very near in time to the tax lien date at issue. The primary issue for this court to decide, which the trial court failed to do so in our opinion, is whether our sale was actually an arm's length sale.
And counsel, you would concede that the $535 that you paid for it was based on the absence of some of these defects that you discovered after the purchase, correct?
That's correct. There was no absence. Obviously, the defects were present, but the $535 was negotiated with the understanding that those defects did not exist. That's
Correct.
right.
And those defects have now been repaired, right?
All of those defects, yes, as of today, all of those defects have been repaired.
So help me understand how it is that these defects that have now been resolved affect the property value going forward.
Sure, it's a good question, Your Honor, and I appreciate the opportunity to explain that. So, as I just said, the tax lien date is January 1st, 2022. So what we're here to decide is what was the value of the property on that day, not what is the value of the property yesterday or today. So on that day, the property existed with, 5 or 6 of these expensive hidden defects.
Is it that exact day or on or about that day?
I believe by statute, it's exactly that day is the day by which sort of the legal fiction that we look back in time and say, this is the value of the property on that day. So every year, properties get updated as of the tax lien day, January 1st, every year. And in this case, it's January 1st, 2022.
Doesn't any property carry a risk of latent defect?
Certainly it does, Your Honor, and that's why it's incumbent in Ohio and in many other states on the buyer to conduct a thorough inspection of the property before purchasing. In this case, first of all, there's no dispute that we were diligent during our inspection phase, but for the record, we didn't waive our right to inspect the property. There were actually 2 independent professional inspections done of the property, one by the seller, which was provided to us, and also one of our own. And, we can get into the specifics of the repairs if you'd like. That's no problem. But at a high level, none of the defects.
Why would the valuation, this purchase price that you two reached, why would that not inherently include in it the risk that there would be these latent defects that couldn't be discovered in the ordinary investigation process?
It's a good question, Your Honor, and I think the answer to that is that in any sale of real estate, certainly there is the risk that whether it's commercial or residential, that there would be undiscovered latent material defects. And in those cases, those are excluded from so let me back up. There is case law finding that there is no arm's length sale if there are latent material defects because if you couldn't.
What would be that case law
Let me.
that says because there's latent material defects?
Yeah, let me, if
That's
you
very
don't mind, just
specific.
briefly consult my notes.
But you know what? It's okay. Just go ahead and finish answering the question. And if you find that you can give that to me later.
I appreciate that, Your Honor. Give me just a couple seconds here.
You know what? You can even give it to me rebuttal. How's that?
Sure, that'd be great, Your Honor.
Okay.
Thank you. So, you know, if it's a latent material defect, then it couldn't have been discovered during the inspection phase of the property. For example, our defects included like a defective sewer drain hidden underneath carpet. There's no way during the process of the inspection that even a professional inspector would be allowed to tear up the carpet and inspect for
Sure,
sewer
that's
drains and
fair.
things like that.
So why doesn't the negotiated purchase price assume that that might be the case? I mean, it could be the case with any property, that there's some hidden crack somewhere that just can't be seen.
I think that's fair, and let me just kind of re-answer the question in this way. I think that's true, but in this case, the sum total of our defects was approximately $75,000. So what I would say is it's the materiality element that would become the focus in your example. So if
So are
it's-
you arguing that there's some threshold so that if the crack is, I don't know, $100 crack or something, that doesn't rise to the level of affecting the value, but that there is a threshold at which it does affect the value?
I think it would be the same materiality standard that courts have applied forever, which is the latent material defect standard. So if there are latent material defects to the property, in some cases, a buyer could have an action against a seller for failure to disclose, things like that. And so I would just adopt the same materiality standard here. I completely agree. My personal belief is that if you have a defect that's $100, that would not rise to the level of reducing the valuation of the property. But here we have, 75 times that. We have
But you fixed it.
75,000.
That's what still troubles me.
That's correct.
Those
but
problems no longer exist.
They no longer exist today. However, they existed in the property as of the tax lien day. So when we were negotiating the value of the property, those defects existed unbeknownst to us.
Right. And without those defects, you valued the property at $535,000.
That's correct.
Those defects don't exist.
They don't exist today, but they did
So the
exist.
property today is still worth $535,000, correct?
I disagree, Your Honor. The property today is worth an unknown amount. There's been a variety of market changes in Hamilton County from January 1st, 2022 to today. So I would suggest it's not, before the court today is not the question of what is the value today, it's what was it in January 2022.
Right, and you evaluated it when you purchased it at $535,000 without defects.
Without defects, correct.
The house does not have defects.
The house does not have defects today. It did at the time, and we were paying taxes on a valuation of the property that was incorrect based on our negotiations, assuming there were not these defects.
And how do you get there? I've taken a really critical look at the Augustine appraisal.
Sure.
And from my assessment, while it acknowledges that there were $75,000 of repairs that needed to be done to the property, it doesn't appear to calculate that amount into the appraised value. It looks to be a very standard comparison of other sales. Just a standard look at this property sold, that property sold, it's got this square footage and that acreage, and we're gonna deduct these numbers to make these properties relatively equal. Can you help me understand how that appraisal assesses your property in light of the $75,000? Where does that factor in?
It's also a good question, Your Honor. I believe Mr. Augustine testified before the BOR that he was looking at somewhat like 50 different factors to evaluate the comparable properties and the subject property. Notably, the subject property is not part of his appraisal. That's because the only way that a sale can be competent evidence of the property's value is if it's an arm's length sale. So here our argument based on the $75,000 in undisclosed repairs is that there was no arm's length sale. And so that data point disappears. Mm-hmm. What he did account for in his analysis was the rough estimation for repairs indicating the condition of the property. And then that let him make the adjustments as appropriate for the comparable properties.
But isn't even if it is an arm's length sale, that's where your second assignment of error kicks in, because it still is a rebuttable presumption that you can rebut by saying, despite it being an arm's length sale, the sale price does not reflect the value, and then rebut it with, what the value is.
That's correct.
Because maybe I'm misunderstanding your argument, because your argument seems to lean into that your only path to getting to where you want to go is through the determination of whether it's an arm's length sale.
Thank you for raising that. That's not the intent of what I meant to convey. What I'd like this court to take away is that in around about 2012, the statute changed such that the court can now consider non-sale price evidence of value even if there is an arm's length sale. And so for many, many years, it was the case that if there was an arm's length sale, that was the price of the property, and I have no problem with that.
And
But-
did the court do that? Did they consider anything that you presented to potentially rebut that presumption?
No, Your Honor. In fact, that's one of the primary bases for our appeal, is that the court seems to have begun and end with just the assumption that there was an arm's length sale. And so just for clarity, when I say the court, I'm referring to Magistrate Judge Barron's decision, which Judge Nestor adopted, but there was no separate analysis, so I just am going to refer to
Which is a de novo
Judge-
review before that court, right?
That's right. And so in Judge Barron's decision, you know, that there are two instances at the top of the discussion and at the end of the discussion where he says, the basis of the Skiles challenge to the board's determination is that the property's valuation should not be set by the arm's length transaction in which they acquired the property for $535. And then at the end of the discussion, he says, since this transaction was an arm's length transaction, et cetera. So in our view, he just begins and ends with the assumption that an arm's length sale occurred when both parties asked him to find out whether a sale occurred at the hearing.
And I have one more question in continuation of what I'm asking you.
Sure.
How did you rebut that presumption?
I think, going back to our discussion of the latent material defects, I think the volume and character of our defects rebut the presumption of an arm's length sale on their own. So even if this court were to find, contrary to the statute and some Supreme Court case law that we cite in our brief that the auditor ignores, I think there is no arm's length sale because of this knowledge component. But even if the court found that there was an arm's length sale, I think the character of the repairs, the volume of the repairs, plus the Augustine report collectively rebut the presumption of value.
The Augustine appraisal characterizes the transaction as arm's length. Should we consider Augustine's opinion in that regard?
Your Honor, I'm not actually familiar with that statement. Could you direct me to it, and I'd be happy to address it if you have it. And if not, I'll check during the rebuttal and
Sure,
I'll address that.
From my recollection, it's at the top. It's at the beginning of the description of the transaction in the report.
I'll take a look at that, Your Honor. Thank you.
And you're nearing the end of your time if you'd like to wrap up.
Yes, Your Honor, thank you. I'll just briefly say, I'll reiterate the position primarily set forth in our reply brief that I think de novo standard is appropriate for both issues. And if there are any questions about why that's the case, I'd be happy to address them on rebuttal. Thank you very much.
Good morning, Your Honors, and may it please the Court. My name is Eric Muniz, and I represent the Hamilton County Auditor, the appellee in this case. As Your Honors are aware, this case is concerning a real property tax valuation complaint. Originated in the Board of Revision, was appealed to the Court of Common Pleas, and is now before this Court.
Can you remind me, I know that I sold my house a year and a half ago, so I'm no longer a homeowner. I'm now a home renter. But can you remind me what's the retroactivity period of the property taxes that are paid in Hamilton County? Do you understand what I'm asking? Aren't they based on a valuation that already, like, a past or
So-
whatever, that you're paying like taxes today, but they're not for today, they're from like a year ago or something like that?
Yes, Your Honor. It's commonly stated that taxes were 1 year in arrears. So, for instance, this year in 2025, people are filing complaints for the valuation as of January 1st, 2024 in the Board of Revision.
Okay.
And I believe payments are also based off of that 1 year in arrears tax bill.
Okay.
The case before this court today, Your Honors, is subject to a abuse of discretion review for factual findings conducted by the trial court. And the law is clear that the issue of valuation is a factual finding that should not be disturbed absent abuse of discretion from the lower court. Legal questions, of course, are reviewed de novo. The case before this court, the appellants did have an opportunity, both before the Board of Revision and before the Court of Common Pleas, to argue the facts of the case. Both the Board of Revision and the trial court found that the appellant did not meet its burden in order to demonstrate that a lower value was appropriate in this case. The auditor respectfully asked that this court affirm for two reasons. First, that the sale price of the subject property did reflect an arm's length transaction, and as such was the best evidence of value. It was appropriate for the trial court to consider that.
I've looked at the magistrate's decision, and I wouldn't say that it's particularly clear to read. So I'm going to ask you, how is it that the appellants failed to meet their burden from your perspective?
A couple things.
And I'm going to go back to like my question of the rebuttable presumption, so bypassing the arm's length, because regardless, there's a burden.
Okay, I do have a couple things in response to that, Your Honor. With regard to the evidence presented, in order for the appellant to overcome a rebuttable presumption of the sale price, they have to show by competent and probative evidence. That's the standard for the evidence presented before the Board of Revision and on appeal to the Board of Tax Appeals or to the Court of Common Pleas. The finder of fact is entitled to apportion weight to the evidence before it in determining whether or not that burden has been met by the proponent of requested value reduction. The evidence in this case consists of an appraisal and then the testimony of the owner, and including a number of documents concerning the repairs and circumstances surrounding the sale. Overall, the record in this case shows that there was a buyer and a seller both acting in their own self-interest. They were not under any compulsion to sell or buy, and that the sale took place in an open market. And in fact, the magistrate's decision, to the other part of your question, Your Honor, although not as clear as perhaps it could be, does in fact lay out a Supreme Court definition for what an arm's length sale is. I think it's incorrect for the appellant to say that the trial court did not consider whether or not the sale was an arm's length. Why would they go through, the motions of defining an arm's length sale in its decision?
He seems to be relying on a footnote, I believe, from a Supreme
I'm
Court
sorry?
case. I believe he's relying on a footnote from a Supreme Court case.
To the contrary, Your Honor, the appellant's assertion of what an arm's length sale is relies on two footnotes. The magistrate cites to a district court decision
Well,
that-
not on the contrary, but in furtherance.
Right. The magistrate's decision cites to a district court decision that cites to a Supreme Court case. And in fact, that case, Walters versus Knox County Board of Revision, is the seminal case in Ohio where the Supreme Court notices that it had not defined what an arm's length sale was prior to that case. That case has been cited to on numerous occasions. The most recent case that I'm aware of is 2018. But with regard to the magistrate's decision, Your Honors, I think it is worth noting that Mr. and Mrs. Skiles did not request findings of fact or conclusions of law prior to or after the issuance of the magistrate's decision. And now on appeal, excuse me.
I'm not sure you've answered my question.
I may have forgotten your question, Your Honor.
That's
would you mind
okay.
reminding me?
Don't worry about it. How is it that they failed to meet their burden in establishing that the sale price did not reflect the value of the property on the date at issue?
How did they not meet their burden? It's difficult to answer that question. It almost feels like trying to prove a negative, but in this case, Your Honor, they didn't meet the burden because the finder of fact found that they didn't do so. They didn't find that their evidence presented was credible or probative enough of the value they were requesting such that the value needed to be reduced. The question isn't specifically whether or not the sale price was the result of an arm's length transaction, although that is part of the analysis. The second part of the analysis is if that is not the value of the subject property, what is the value? And unless they could show by competent and probative evidence what that value should have been, there's nothing for the lower court to do with regard to changing the value. They can't just change it because they see the sale price wasn't accurate. They have to see evidence in the record that shows that there was a different value that it should have been.
Can you point where in the magistrate's decision it reflects that the magistrate considered the evidence presented by the appellants with regard to what they were asserting, that they were presenting in order to rebut that, in order to assert that the sale price did not reflect the value?
Your Honor, the closing paragraph of the magistrate's decision says, after an independent review of the evidence in the record. That's what we have in the magistrate's decision. As I was mentioning a minute ago, there was no request for findings of fact or conclusions of law made by Mr. and Mrs. Skiles. And for this magistrate's decision to be dissected on appeal feels a bit contrived, where they had an opportunity to get specifics from the magistrate so that they would have that to show whether or not the magistrate was following the law. And in fact,
What level of fact-finding is required? Could the magistrate have just put on a one-sentence order that said the appeal is denied and the board's decision is affirmed?
I believe the magistrate could have, Your Honor. According to the civil rules, Civil Rule 53D3A2, a magistrate's decision may be general unless findings of fact and conclusions of law are timely requested by a party or otherwise required by law. I'm unaware of any law that requires magistrates' decisions with regard to valuation complaints to be more specific than general. I mean, this is the rule of civil procedure governing magistrates' decisions. The magistrate chose to, in roughly 2.5 pages, attempt to explain his decision. It wasn't just a one-sentence decision, but looking at the volume of evidence in the record, just documentary evidence, testimony, and an appraisal, it's not unfair to think that the magistrate, had he been asked to issue findings of fact and conclusions of law, would have done so in a more robust manner.
Counsel, isn't there always some inherent risk in purchasing real estate that you're not going to discover all of the potential defects despite your best efforts?
I would agree with that, Your Honor. There is a risk. And
that doesn't change the nature of it being a arm's length purchase, does it?
It does not, Your Honor. Again, going back to the definition of arm's length sales in Ohio, as articulated by the Supreme Court, an arm's length transaction has 3 characteristics. It is voluntary, that is without compulsion or duress. It generally takes place in an open market, and the parties act in their own self-interest. And the record shows, the sale in this case very clearly falls under that definition. There was a seller who was attempting to sell their property. They disclosed that they had done an inspection. They invited a buyer to do their own inspection. That inspection occurred. There was a negotiation after the inspection period. There was a list of defects, repairs were requested, and ultimately the buyer agreed to the purchase price that the seller was willing to agree to, and the transaction occurred. Yes, there is risk. There was a question from this court with regard to whether or not there's a threshold for what might undo an arm's length transaction. The appellant reasonably suggested that a $100 crack in a foundation or a wall might not undo an arm's length transaction, arm's length nature of a transaction. But notably, there was not an articulation of what amounts to enough. And in fact, I would assert that there is no threshold. It is a determination made by the fact finder. Based off of the totality evidence that they are seeing, is there enough evidence to suggest that the sale price shouldn't be deferred to?
Counsel, can I ask you to indulge me in a hypothetical?
Absolutely, Your Honor.
Let's imagine that a buyer purchases a piece of property with a structure on it for $10 million. And after the purchase goes through and is closed, the very next day, they discover there's a sinkhole and the property's going to fall over within 10 days. And they're able to bring forward a structural engineer and an environmental expert, and it's just with beyond doubt, this thing is going to fall over and it's valueless. In such a case, is the value of the property for tax purposes $10 million or is it zero?
Your Honor, the value of the property, the best evidence of value of the property would be the sale, but there are proceedings to allow that to be overcome. And I'm not trying to evade your question, but it really is about what evidence was presented if there was a proceeding before the Board of Revision in that hypothetical case.
And so it's your position, and I'm not meaning to put words in your mouth, but what I'm hearing you say is that in such a hypothetical, the purchaser could, with evidence, justify a case for zero.
Zero would be hard, but yes, they could
Or
certainly
something-
get a lower value.
Something less
with
than
evidence.
10 million. So what makes this case different from that one?
Well, the severity of your example, I think, is a distinguishable factor. The appellant does cite to a few cases concerning, there was one, I think, that had a substantial termite infestation found after the transaction, and this goes back to the early 90s, but the court in that case found that that transaction was no longer arm's length because of the severity of the termite infestation. Again, this comes down to whether or not the evidence presented shows that the sale is so unreliable that it shouldn't be considered arm's length. But again, that's only half of the equation. The evidence must also show that there is a different value that should be put in place of the sale. And the trial court, in considering the evidence, also the Board of Revision in considering the evidence, so at two stops at this point, the evidence presented by Mr. and Mrs. Scales was found not to show that a different value should be put in place of the sale.
Counsel, going back to Judge Kinsley's hypothetical, in this case, the defect was repairable, right? The sinkhole, according to hypo, you can't fix it. Here, the items were repaired, like it never ever happened. So I'm still struggling with how this defect that is now fixed can negatively impact the value that they were willing to pay for without the defects.
That's an interesting question, Your Honor, and again, it's sort of a factual analysis for the finder of fact to determine. By way of example, I know for a fact certain home maintenance type things are not considered to reduce a property's value when it is needed if your property needs a new roof or if you replace an air conditioning unit. That doesn't mean that the old air conditioning unit means your house is worth less. It meant that, you have to do some home upkeep, and this is what your house is worth. You have a new air conditioning unit. It might be more marketable because of it, but for valuation purposes, it was a home with an air conditioning unit. So that's an example. It really comes down to, what are the repairs, and whether or not it so impacts, in this case, because there was a sale, it's whether or not those repairs are trying sufficient enough to undo what is considered best evidence of value under Ohio law. I feel like I may have danced around the question a little bit. It was not my intention.
No, it's fine.
Okay.
I just want to have clarity. You mentioned the termite case.
I did.
In that case, how did the court apply the three elements? Which element did they use to determine that it was not an arm's length sale?
In short, Your Honor, I don't know. To answer that question, I would imagine it had something to do with
And can you give me that?
The self-interest portion of that element. I'm not sure that the court in that case actually addressed the three elements quite like that, and I
But
would,
it did address arm's length,
it did, Your
as
Honor.
opposed to saying it was an arm's length, however, what was provided was sufficient to rebut the presumption that the value was based on the sale.
That case and the other case cited by the appellant, Your Honor, actually both have procedurally unique elements in that the appellant was not an owner seeking to have a value reduced. It was rather, I think it was a school district in both cases, trying to get the value increased, where the lower fact finder, the Board of Revision, actually had already decided that the sale price was not the value of the property. So that question was seeking to be reversed on appeal.
Thank you.
I believe I'm about out of time or completely out of time, Your Honor. So respectfully, the auditor asks for that this court affirm. Thank you.
Thank you. You may.
A couple of things to bring up here with me, so just bear with me for a second.
Of course.
May I proceed?
You may.
I'm going to pick up right where we left off about the termite case and the other case. These are on page 31 of our opening brief. It's the City of Cincinnati v. Hamilton and the Groveport-Madison v. Franklin County Board of Education cases. Your Honor, you had asked me in my opening remarks about how a latent material defect can affect the value of the property and whether or not the purchase price should account for that risk. These are two examples where, despite, for example, in the City of Cincinnati case, the house selling for $280,000, the court found that when the buyer purchased the property, despite taking precautions, she was unaware of a latent defect severely affecting the condition of the property, and that latent defect severely affected the property's value on the tax lien date. That's one example. And in the other, in the Groveport case, the court found that even though the property sold at $165,000, the value should be $59,000 because, quote, the sale price did not accurately reflect the true value of the subject property on the tax lien date. So those are what I should have referred to when I was fumbling around looking for a case. I also want to point out just a couple things that counsel indicated. First of all, the sufficiency of the detail in the magistrate's decision is a brand new argument. It's not addressed in the briefing at all. Today was the first that I had heard of that. In our view, when I read the magistrate's decision, he does walk through kind of the history of the background of the case. He describes, his take on the Augustine appraisal, for example, and makes, as discussed in the briefing, some legal errors and factual errors along the way. But we looked at this and determined that it was sufficiently detailed for appeal. It wasn't just a one-paragraph type thing, and so that's why we didn't pursue findings of fact.
Can I ask you, where in the magistrate's decision would you point to support that the magistrate did not consider the evidence presented on what you consider to be the value of the property?
Thank you, Your Honor. So counsel even referred to the question a couple times as like whether the evidence is credible or probative enough. Is there enough evidence to suggest they haven't met their burden? None of that language is in the court's decision. As I said and pointed to in my opening remarks, he just refers to the arm's length transaction as though it just happened that way. But there's no analysis whatsoever about any particular defect, let alone our knowledge thereof. I'd also like to point out that, running close to time here, Your Honor, you had asked me also about Mr. Augustine's reference to arm's length sales. So I believe I found what you were referring to, and I don't mean to pull out this huge tome, but this is from TD 12, which is part 1 of the BOR record. This is the Augustine appraisal. And I noticed that in the opening pages, he refers to the subject property has several recent arm's length transfers. And that reminded me that the property was sold twice in March 2021 before we bought it in January 2022 for like $170,000 and $200,000, and then we bought it for $535,000. So what I was going to point out is, we argue that our sale was not arm's length, obviously, but if you're going to consider ours arm's length, those should be considered as well. I mean, those are recent arm's length sales of the property. There's no dispute that the March 2021 sales were arm's length, and that's all discussed in our briefing as well. I think, unless the panel has any other questions for me, that's it. Thank you very much on behalf of my wife and I for your time today.
Thank you. We will take the matter under submission and issue a timely decision. Thank you both for your arguments this morning. Enjoy the rest of your day.